Hey everyone, Scott Rattigan here from Functional Lawyer, and today we are talking about professional corporations. What are they? How are they different from regular corporations? Are there any naming rules that you have to follow that are different? Different licensing questions, and then some protections for you for malpractice, and then some taxation rules as well. So let's get right into it. What is a professional corporation? It's just a corporation that's formed by licensed professionals in order to provide the service that they're licensed to provide services for, which is a long way of saying just a group of licensed professionals forming a business, right? So there's some naming conventions that are in play here. Most states' rules vary a little bit here, but for the most part, you may be required to have the initials PC for professional corporation, PA for professional association, or PLLC as part of your business name. You may also have to include the type of profession that you're going to practice in the name. So medicine, law firm, accountants, CPA, something like that. You may have to add that to the name of the business as well. And there may be some other rules, including not indicating that you're doing something you're not licensed to do. So if you were opening up a medical clinic, you shouldn't put accountants in there. A bad example, but it just needs to be transparent, right? Then there are some rules over who can own a professional corporation or professional LLC. Sometimes everybody that's an owner has to be licensed of the same type. In other states, the licensed professionals have to own at least 51% of it, or they just have to have a majority of ownership shares as licensed professionals. So definitely check with your state about who can co-own a professional entity. That's really important in states in which professional entities may be required. So some states like California and New York and many others require professionals to file and form a corporation or entity that is a professional in nature. Other states allow you the option to choose whether you want to file as a professional entity or as the generic version of that entity type. So just a regular corporation, regular LLC. And so you want to check definitely with your Secretary of State and sometimes your licensing board as well, although the Secretary of State is usually more helpful for your state's rules. And that includes how to file as an entity, right? So when you go to form it, they may require that you get a certificate of good standing from your licensure board or otherwise prove that you are who you say you are and that you're licensed to do the thing that you want to do. New York is very weird. They go through the Board of Education. Before you can file your entity type, you have to get approval from the Board of Education of New York. Similarly, California requires that you get the name approved by the medical board before you can file with the Secretary of State. So definitely check with your state's rules because sometimes they're different and unexpected as well. So if you had a choice going through all these hoops, why would you pick professional versus regular? So let me back up and ask a different question. Why do we form entities at all? Two main reasons. One is different tax treatment, but two is, and more importantly for this conversation, limitation of liability. So we form a regular LLC or a regular corporation generally to shield us personally from the liability or debts of the company. So you start a company and either you go bankrupt or you owe a ton of money and then you go bankrupt and then you dissolve the company. Nobody can come, unless you were acting in fraud, nobody can really come and get your house, get your personal effects. They're limited to the assets of the company. And that's the same if there's a lawsuit or there's any other kind of creditors that are coming to get the assets of the company. They usually, there are some exceptions, but they usually can't come after your personal assets. So car, house are usually the two biggest ones. Bank accounts, retirement funds are the next two that are usually pretty big. And so that's why we form entities in the first place. Now, if you're in a group with 3 or 4 doctors and everybody is practicing medicine, it's only a matter of time until somebody gets a malpractice suit against them or the threat of a malpractice suit against them. If you practice long enough, you'll get at least one in your career. But the key thing with professional entities is you, as an owner in the business and a licensed a licensed professional that owns a share of a professional corporation, you are shielded from the malpractice liability of your peers, your co-owners. So generally in a business, something done in the course of the business is imputed to the business as responsible for that. That makes the business responsible for any debt. So if an employee is driving to deliver something on behalf of the business and they get into a car wreck, that's the business's liability. But here for professional corporations and the other types, LLC associations as well. But for professional entities, each individual person is really responsible for their own malpractice. And then if John down the hall was really negligent and then they get a malpractice judgment against him for $5 million, that's up to John and his malpractice carrier. You, as a co-owner of the business, are not liable for that, that malpractice suit. However, there is an exception if there is gross negligence going on. So you see John come in stumbling from the night before and he's clearly drunk or hungover or both, and then you don't say anything, you don't stop him from performing that open heart surgery that morning, then you could be liable as well if you know and don't stop something pretty bad. And you're not shielded from all liability as well. You are still responsible for your own actions, your own negligence or alleged negligence. So you're responsible for your own actions that could potentially lead to malpractice suits down the road too. So it's not a shield of all liability. It just kind of puts liability in silos for each professional that owns the business. That's the main draw for choosing professional entities if you have a choice. Taxation. So the other reason why we start entities is for tax treatment. By default, professional corporations are taxed like a C corporation, but they are eligible in a lot of respects to apply for S corporation status. If you're not sure what S corporation status is, it just means it's not taxed twice. The money that comes into the business is not taxed twice, but there are some additional rules that you have to follow in order to be eligible for that. Most people that are in our space in functional medicine, that are forming small companies with American citizens and a few other rules. But just knowing that the taxation for a professional corporation or professional LLC is no different than a regular corporation or LLC. You still have either double taxation or you can file for S Corp status if that's something that you and your accountant agree is the best situation for you. So to recap, professional entities, really, the number one draw is siloing malpractice liability amongst each member who is an owner. There's not a whole lot of difference between the regular entity type and the professional entity type. There are some more naming restrictions, and then there are some formation rules that are a little bit different. So definitely check with your Secretary of State in order to see what's the proper way to form a professional corporation in your state. And always check with an accountant to determine your best tax status as well. Thanks. We'll see you guys in the next video.